There's something quietly unsettling about the idea that everything you've spent your life building could end up tangled in a slow, public, and expensive process after you're gone. Not because you didn't care, not because you didn't plan, but simply because no one ever sat you down and explained how the system really works. And that system is called probate. Now, before we go any further, let's slow this down for a second, because probate has developed this almost villain-like reputation. People hear the word and immediately think delay, cost, stress, frustration. And while all of that can be true, the intention behind probate is actually something very different. It exists to protect you. Think about it this way. Once you're no longer here, you can't sign documents. You can't confirm decisions. You can't step in if something goes wrong. So the court steps in as a kind of safeguard to make sure your assets go exactly where they're supposed to go. It's about preventing fraud. It's about making sure no one takes advantage of your absence. But here's the reality most people don't realize. The moment the court gets involved, things slow down. A lot. What could have been a simple transfer becomes a process, a public one that anyone can look into. In fact, you can literally go online today and look up the estate details of famous individuals, including someone like Prince. His estate became a long, drawn-out probate case, visible for the world to see. And that's not unusual. On average, probate can take months, sometimes even close to 2 years, and it can cost anywhere from 3% to 7% of the total estate value. Pause for a second and think about that. If your estate is worth $1 million and everything goes smoothly, even at the low end of 3%, that's $30,000 gone. Not because of bad decisions, not because of mistakes, but simply because of the process. And that's why so many people start asking a very important question: how do I avoid probate? Now, the gold standard answer, the one you'll hear most professionals recommend, is setting up a trust. And for good reason. It's powerful, it's flexible, it gives you control. But let's be honest, not everyone wants to set up a trust. Maybe it feels too complex. Maybe it feels too expensive. Maybe it just feels like too much. And that's okay, because there are other paths. Not perfect ones, not always ideal, but real options that, depending on your situation, might actually work. So let's walk through them, slowly, honestly, the way someone who truly cares about your financial future would explain them to you. Option 1, giving your assets away. At first glance, this sounds almost too simple. If probate happens because assets are still in your name, then why not just remove them from your name? You give your house to your children. You transfer ownership of your assets. Problem solved, right? Technically, yes. Once something is no longer in your name, it's no longer subject to probate when you pass away. But here's where reality sets in. The moment you give something away, you lose control over it. That house you worked decades to pay off, it's no longer yours. Even if your children are kind enough to let you live there, legally the power has shifted. You can't sell it, you can't refinance it, you can't make major decisions about it without their approval. And then there's something even more important, something many people don't discover until it's too late. You lose a major tax advantage called the step-up in cost basis. Without getting too technical, this benefit can save your heirs a significant amount in taxes when they eventually sell the property. But when you gift the asset early, that benefit disappears. And there's more. In many cases, transferring property can trigger a reassessment, which could lead to higher property taxes for the exact same house. So yes, gifting avoids probate, but it often creates a completely different set of problems, ones that can quietly cost you far more in the long run. Option 2, joint tenancy with rights of survivorship. This is one of the most common strategies people use, especially in families trying to keep things simple and avoid legal costs. The idea is straightforward. You add someone, often your child, as a joint owner of your property. And when you pass away, ownership automatically transfers to them. No probate, no court involvement, no delay. It feels efficient. It feels smart. But there's a side of this that many people don't think through. First, control becomes shared. You're no longer the sole decision maker. Want to sell the house? You need their consent. Want to refinance? Same thing. But the bigger issue is risk. The moment your child becomes a legal owner, your property becomes tied to their financial life. If they face a lawsuit, your home could be at risk. If they go through a divorce, your home could become part of that situation. If they accumulate debt or declare bankruptcy, your home could be pulled into that as well. Suddenly, something that was meant to protect your legacy becomes exposed to risks you never intended. And that's a hard reality to face. Option 3, naming beneficiaries. Now, this is one of the simplest and most accessible options available. For certain types of accounts, like bank accounts, retirement accounts, and investment accounts, you can name a beneficiary. That means when you pass away, the asset transfers directly to that person. No probate, no court involvement, no delay. It's clean, it's efficient, and in many cases, it works beautifully. But even here, there are limitations. Not every asset allows this type of designation. And more importantly, you have to think carefully about who you're naming, because when the asset transfers, it goes directly to them, often in a lump sum. There's no structure, no protection, no guidance. Now imagine this. What if your child is still young? What if they're not financially responsible yet? What if they're dealing with challenges you don't fully see? That inheritance, instead of being a blessing, could become overwhelming. And in cases where a beneficiary has special needs, receiving a lump sum could even disqualify them from essential government benefits. So while this option is simple, it requires thoughtful consideration, because simplicity without foresight can lead to unintended consequences. Option 4, transfer on death deeds. Some states offer something called a transfer on death (TOD) deed for real estate. It works a lot like naming a beneficiary for your bank account, but instead, you're doing it for your home. You record a deed that names who will receive the property when you pass away. And when that time comes, the property transfers automatically, no probate. Now, on paper, this sounds like an ideal solution, but there are a few important caveats. First, it's not available everywhere. Second, it tends to work best in very simple situations, like when the property is fully paid off and you're naming a single beneficiary. Because the more complex your situation becomes, the more fragile this solution can be. Still, for the right person in the right situation, it can be a useful tool. Every single strategy we're talking about is trying to solve the same problem. How do you make sure your assets are no longer in your name when you pass away, so they don't get pulled into probate? That's the core principle. But as you're starting to see, how you do that matters just as much as whether you do it. Option 5, using an LLC or corporation. This one sounds a bit more advanced, and in some ways it is. The idea here is to place your assets, like real estate, inside a business entity, such as an LLC, limited liability company, or an S corporation. Instead of you personally owning the asset, the company owns it. And then, within that company, you create rules, called operating agreements, that dictate what happens when one of the owners passes away. So when you die, ownership doesn't transfer through probate. It simply shifts within the structure of the company. Clean, organized, controlled. At least that's how it looks on the surface. But let's slow down again, because there are trade-offs here that people often overlook. One of the biggest ones involves taxes. When you own a home as an individual, you may qualify for something called a home sale exclusion, which can allow you to exclude a significant portion of capital gains when you sell your home. But once that property is owned by a corporation, that benefit disappears. Now, if the property is sold, you could be paying taxes on the entire gain, no exclusions. And that can be a substantial financial hit. There's also something else to consider. In many places, your personal residence is protected by what's known as a homestead exemption, a layer of protection against creditors. But that protection typically applies to individuals, not corporations. So by moving your property into an LLC, you might actually be giving up protections you didn't even realize you had. This option can work, especially in business or investment contexts. But for personal assets, it's something you need to approach with care and full understanding. Option 6, charitable life estate. Now this one is different. It's not just a financial decision, it's a deeply personal one. Here's how it works. You donate your property, like your home, to a qualified charity, but you retain the right to live in it for the rest of your life. So nothing changes for you day to day. You still live there, you still maintain it, you still pay the expenses. But legally, the ownership has shifted. And when you pass away, the property goes directly to the charity. No probate, no delays, no complications. And for some people, this feels incredibly meaningful. It's a way of leaving behind something that continues to do good long after they're gone. But let's be honest about the other side of this. This is a permanent decision. You can't wake up 5 years later and say, you know what, I've changed my mind. You can't decide to sell the property. You can't redirect it to your family. You are locking in that choice for the rest of your life. And that requires a level of certainty that not everyone is comfortable with. So while this option can be beautiful in the right context, it's not one you make lightly. Option 7, small estate simplification. Now this last option is, well, it's the simplest of them all, but it's also the most limited. Some states have what's called a small estate threshold. If your total assets fall below a certain value, you may be able to go through a simplified version of probate, sometimes called summary probate, or what I like to think of as a lighter process. No attorneys, less paperwork, faster resolution. In some places, that threshold might be around $25,000. In others, it could be closer to $185,000. But here's the key thing to understand. For most people, their estate exceeds that limit. And even if it doesn't today, it might in the future. So while this option exists, it's not something you can reliably build a long-term plan around. It's more of a fallback than a strategy. Bringing it all together. Now take a step back with me for a moment. We've just walked through 7 different ways to avoid probate, each with its own strengths, its own weaknesses, its own hidden complexities. And if you're feeling a little overwhelmed right now, that's completely normal, because estate planning isn't just about documents or strategies. It's about decisions, real decisions, personal decisions, sometimes emotional decisions. It's about asking yourself questions like, who do I trust? What kind of control do I want to keep? What risks am I willing or not willing to take? And most importantly, what kind of legacy do I want to leave behind? Because at the end of the day, this isn't just about avoiding probate. It's about making things easier for the people you care about. It's about reducing confusion, reducing stress, reducing conflict, during a time when they're already dealing with enough. A moment of honesty. So let me ask you something, gently, honestly. Why are you trying to avoid setting up a trust? Is it the cost? Because yes, working with estate attorneys can feel expensive. Is it the complexity? Because let's be real, legal documents can feel intimidating. Or is it uncertainty? Maybe you've looked at those DIY platforms and something just didn't sit right. You weren't confident. You weren't sure if you were doing it correctly, and so you paused. If that's where you are, I want you to know something important. You're not alone. A lot of people find themselves right in that exact space, wanting to do the right thing, but not feeling fully comfortable with the available options. And that's where a middle path can sometimes make sense. Working with someone, a certified estate planner or a financial advisor, who can guide you through the process, not at the high cost of traditional legal services, but also not leaving you alone to figure it out. Because sometimes what you really need isn't just information, it's clarity. It's someone saying, here's what makes sense for you, based on your life, your goals, your family. If there's one thing I hope you take away from this, it's this. Avoiding probate isn't about finding a shortcut. It's about finding the right fit, the right balance between control, cost, simplicity, and protection. And for most people, not all, but most, a trust still remains the most complete solution, because it doesn't just avoid probate, it gives you structure, it gives you flexibility, it gives you peace of mind. But if a trust isn't the path you're ready to take right now, at least you now understand the alternatives, not just what they are, but what they truly mean. And that understanding, that's where real financial confidence begins.